I spend a lot of time speaking with people that have been charged with drug driving. One of the most common questions I'm asked is, how do I defend a drug driving case? Is there any way around what's going to be a mandatory 12-month driving disqualification or 3 years if you have a relevant previous conviction in the last 10 years? And one of the most common and one of the most effective drug driving defences that you may be able to argue is what's called post-driving consumption. So listen to this video. If you've got any questions about your drug driving case, make sure you get in touch. Feel free to subscribe to the channel. There'll be plenty more videos that will follow on drink, drug driving, road traffic matters. Feel free to like the video as well. And any questions, please get in touch. We always give free legal advice over the phone. Now, post-driving consumption is a complete defence to an allegation of drug driving. What I mean by that, if the court accepts that you consumed a drug after driving, post-driving consumption of drugs, then you will be found not guilty of drug driving. And this situation commonly applies in circumstances where you might have a controlled substance in your vehicle. Let's say, for example, you've got cannabis or cocaine in the car. You know, as well as anyone does, that those drugs are illegal. You can't possess them. Cannabis is Class B, cocaine is Class A. Now, post-driving consumption of drugs commonly arises in circumstances where a suspect will panic having been pulled over by the police. So take, for example, you're driving down the road, you see the police in your rearview mirror, and you've got a feel for it. You know they're going to stop you. You can usually tell when the police are going to stop you and pull you over. You know there's drugs in the car, cocaine, cannabis, whatever it might be, and you know it's illegal to possess those drugs as well. You've got previous for possession, you don't want another one on your record, penalties get harsher a second time round. It might be that you've got a clean record, you can't have possession on that record. So what do? In the heat of the moment, you consume the drugs. You eat them in an attempt to conceal them. Now that may be a crime in itself if you are consuming those drugs in an attempt to conceal them, but it's not a drug driving offence. If the vehicle by that point is stationary and the police, let's say they're approaching the car or they're carrying out the checks in the vehicle a few seconds before they get out and walk over to the vehicle, and they've walked over to the vehicle, you eat the drug, they may or may not see that, but that can be a complete defence to the allegation, because you can then argue that the only reason you were over the legal limit when the blood sample was taken was because you consumed the drug after driving. Now, all the police can really say is that we didn't see you consume anything, but of course they may not have done, because how quickly can a person consume drugs while sat in a car? It's a matter of seconds to consume a drug and to swallow it. And so the police can't say that you didn't consume the drugs after driving. They can only suggest that you're not telling the truth, and the reason that you're arguing this defence now is because you were over the legal limit and you're trying to figure out a way around it. And that may be their case, that may be their argument. But if your argument is, well look, I consumed the drug after driving in an attempt to conceal it, and that can be a complete defence to the allegation, again, what's called post-driving consumption. And the way in which you try and establish that defence and argue it in a courtroom is with the use of expert evidence. Now, I work very closely with senior toxicologists, very experienced toxicologists, who can produce reports in cases like these. So the client comes to me and says, well look, Connor, I consumed cocaine when the police were approaching the vehicle because I know possession of cocaine is illegal and I didn't want that on my record. I was then swab tested, and of course I was over the legal limit for that reason. I didn't tell the police about it, I didn't want to get myself in more trouble. Then I would explain to that person, you've got a complete defence. How we prove that is we instruct an expert, and the expert, based on your height, your weight, your age, the timing of consumption, so when exactly you consumed the drug in the car, and then when the blood sample was taken, if that all matches up, then you would have a positive expert report. So whilst the burden falls on you to establish on a balance of probabilities that you consume the drug after driving, with an expert report and with a good explanation as to why you might have done that, and that can be a really effective defence to use in these kind of cases. It's a really tricky one for the prosecution to work around, because the police may not actually have been at the vehicle when that consumption took place. So if you'd like to talk more about post-driving consumption in drug driving cases, then please get in touch. I'm happy to explain how it works, how we go about instructing a toxicologist, and of course the costs involved as well when you've got solicitors that are acting for you. Feel free to subscribe, like the video. If you want to comment, I usually respond to comments in videos as well, and you can find all our contact details on our website.